Our attention will be focused on Slovenia now. Frane Stanic, who is going to talk about it, is also a professor of University of Zagreb, where he obtained his PhD in 2011. Among his different important responsibilities, he is a member of the Legislative Committee of the Croatian Parliament. His main interests are different aspects of administrative law, as well as church-state relations. Professor Stanic, please proceed.
Thank you very much. I would like to greet all the present and thank the organizers for allowing me to be on this conference, and of course to thank all my predecessors on very, very interesting lectures. First, a little disclaimer, as I am a professor at the Zagreb University in Croatia, and I'm giving a presentation on Slovenian regulation of the question of use of public religious symbols in public use. So I hope that I am up to the task. Slovene society cannot be described as particularly multicultural or heterogeneous. Compared to a number of other European countries, it is virtually homogeneous. Obviously, after 1991, additional expression of numerous religious pluralism occurred, and today the number of registered religious communities in Slovenia is 55, which is rather a lot. In Croatia it is 53, but we have a very liberal system of registration, and Slovenians have a rather stricter one, but they have 55 registered religious communities. Of course, the Roman Catholic Church is by far the largest, up to 80% of Slovenian citizens if baptism is taken as a formal criteria. One of my main hypotheses of this presentation and of my paper is that the model of choice of state-church relations is the most important one for the position of religion in public sphere, and therefore for the legal regulation of presence of religious symbols in the public sphere. That is why a great portion of my presentation will be dedicated to explanation of Slovene model of state-church relations. Some scholars in Slovenia say that they have a similar approach to the position of religion in public sphere, and of course then to the use of religious symbols in public sphere as France, or that their model is the closest one to the famous French model of laïcité. However, my second main hypothesis is that that is not the case. Perhaps it is so on paper, but it will be shown through the decisions of their constitutional court and analysis of their legislation that that is not really the case. It would be fair to say that the relations of churches and other religious communities in Slovenia with the state resemble the cooperation model, with some strict exceptions that will be shown in this paper, which are, however, crucial for the question of whether the presence of religious symbols in public sphere in Slovenia is permitted, prohibited, or not. The answer is, as will be shown, not without but-ifs. Slovenia, of course, as other mentioned countries, was caught up in the third wave of democratization following the Second World War. The course of transformation of these countries and their capacity to establish democratic institutions and political relations is determined by various sources and relations, namely A, the redefinition of the nation or the nation state, in which important part is played by the so-called national churches, as they break out of their marginalization through the communist rule, as we already heard. The churches are in renewal, gaining importance, and so on. B, the question of the relationship between democratic institution and the economic restructuring of the society. And C, eradication of the communist party's ideological monopoly. The new Slovene constitution marked the departure from the negative perception of religion and initiated a search for new foundations of church-state relationship. However, the path Slovenia took does not resemble most of the former Yugoslav republics and Croatia, which all did opt for the separation of church and state, but with strong institutional ties with the most numerous religious community. Catholic Church in Slovenia, in Croatia, Serbian Orthodox Church in Serbia, Islam community in Bosnia, and so on. Slovenia, on the other hand, envisaged its own state-church relations model, which can be linked to the famous French system of laïcité. But one thing should always be remembered. During all of these historical developments, the Catholic Church had decisively influenced the development of Slovenian national culture and politics. Slovenian model of relations between the state and the church is established by their constitution by Article 7. In their legal theory, it is said that equality of religious communities has been understood by the state as an undiscriminating affirmation of the whole religious field. So they put much emphasis on equality before the law. The meaning of this is that different religious communities are equal before the law, and some say that they have the model of laïcité, and the principle of separation establishes the secularism of the state. This means, in their views, that the state must not be tied to any church. The state must not privilege, discriminate against, or to opt for religiosity or non-religiosity. In their legal theory and practice, the principle of separation of state and religious communities is predominantly understood and interpreted in terms of consistent and rather strict separation modeled on states with more pronounced separation of the state and church. But such a position is not to be attributed to the constitutional order, but rather to the legal and executive derivation of this constitutional principle, and in particular, the influence of the previous political system. Some Slovene authors believe that the principle of separation in state and religious communities in the modern democratic state that limits itself is in fact unnecessary. Namely, today not only churches are separated from the state, but also the whole area we call civil society. The question that should be asked is then this: does it follow from this that religious institutions and organizations must be even more separate from the state than other economical, recreational, cultural, and educational associations, and what this should mean? Or can the attitude of the state toward the church be comparable to the attitude of the state to other institutions and associations in the field of civil society? Namely, as some authors say, a laic state does not take upon itself any religious roles. So therefore, it should not be aggressive towards religion. It should not feel threatened from religion, and therefore it should and must cooperate with religion as this is useful for the citizens and public good. So all Slovenian authors agree that Article 7 of their constitution, in conjunction with Article 41 of their constitution, prescribes three principles. First, the principle of separation. Second, the principle of free action of religious communities. And third, the principle of equality. However, when we take Articles 5, 7, and 41, it is clear that the Constitution did not opt for the exclusion of religion from the public sphere, as was prescribed in the previous communist era. The purpose of the principle of separation is therefore not to protect the state from religious and other groups and their association, but to establish full freedom of conscience and equality of all people through its neutral stance. So the state must be neutral towards religion. This principle of neutrality, separation through neutrality, can be seen through functional and institutional elements. Functionally, state neutrality safeguards the state and religious communities in ensuring that the state is religiously or ideologically neutral in its activities, and it does not identify itself with any religious or world communities. However, this does not mean that the state should or must suppress religious communities to the outskirts of public life, as that would represent discrimination. Institutional elements demarcates the state from the churches, or separates the state from the churches, religious groups, and worldview groups. The principle of separation forbids churches from performing functions which are reserved for the state, on the sovereign state. For example, their constitutional court said that the religious groups cannot be the ones performing marriages, keeping registers, and issuing public documents. The state neutrality, however, does not command the states to be indifferent to the religious needs of the people. All elements of separation principle, which I have mentioned, are intertwined, and only in proper context do they enable the full implementation of the constitutional provisions and the appropriate legal interpretation. If the state would treat any religious community or all religious communities unequally or interfere with their autonomy, it would breach its neutrality. So, according to some authors, Slovenia has problems when it comes to applying these principles. In their view, the Catholic Church is always privileged, with the exception of the communist era. Its privileged position continued in democratic Slovenia, especially after the coming into the force of the Religious Freedom Act in 2007. Because this religious act, which came into force in 2007 with a majority of only one vote, so 46 out of 90 from the parliament, and it was a huge political question. It was under scrutiny of the Constitutional Court, and a lot of Slovenian politicians, legal theorists, and all regular people claim that this Religious Freedom Act is unconstitutional and that it breached state neutrality, because it enabled for the state to cover wages for clergy employed in hospitals, police, prisons, homes for the elderly, and enabled for tax exemption. And it enabled that the state pays 0.5% of the taxpayers' income tax to religious community of his or her choice. But the Constitutional Court confirmed that the state, although it is separated from the churches, is entitled to financially aid religious communities. Namely, the court said that the separation principle does not hinder the state to establish similar relations with religious communities, as it has done with other forms of civil society. Therefore, state subsidies are allowed. And it is important to mention that the Constitutional Court stated that religious communities are organizations of general good. Later, it broadened its interpretation by claiming that the principle of separation primarily concerns the autonomy of religious communities in their own sphere, the secularization of public life, and neutrality of the state towards the religious communities. The aspect of neutrality was further explored in the opinion of the Constitutional Court on the constitutionality of the treaty with the Holy See, in which the court stated that this principle prohibits the states from identifying with any religious or other belief and the establishment of the state religion, as well as the promotion or prohibition of ideological beliefs. Although Slovenia is seen as a laic state like France, it has an international agreement with the Holy See, but this was not the first agreement in Slovenia between the state and religious communities, as the first one was the agreement on legal status of the Evangelical Church in 2000. And later on, 5 more such agreements were signed between the government and the respective religious community. It is important to note that the Constitutional Court decreed that any individual's perception of the practice of religion must not constitute such a confrontation with the religious belief that means an encroachment on negative religious freedom. An example would be a mandatory oath on the Bible while stepping into a political function, very importantly, crosses in classrooms and prayers and blessings at graduation ceremonies in public schools. Now we come to the field of use of religious symbols. It is not regulated in any way through formal legislation, with the exception of public schools. However, it is not customary to publicly display religious symbols in public, as this is seen as a breach of state neutrality. Although there is no formal regulation of use of religious symbols in public sphere in Slovenia, except for use of religious symbols in public schools and kindergartens, but even this regulation is rather implicit, not explicit. However, there are numerous religious symbols in public spaces, as there are at least almost 3,000 objects intended for worship in Slovenia. And of course, religious motives are very present in arts and culture. Regarding the presence of religious symbols in media, their use is not in any way hindered, as Constitution guarantees freedom of expression. It is very important to mention that the Slovene public television broadcasts every Sunday the religious series Obzorja Duha and a Sunday Mass, and it has a special editor for religious program. Religious communities may freely establish their own public media in which they can use religious symbols as they choose. The constitutional protection of the right of religious freedom also includes religious assistance to persons that work, reside, or are being held in public institutions of different types. This, of course, means that they are entitled to personal religious items, for example, books, and, for example, public religious rights in such institutions. According to the Religious Freedom Act, such institutions are the army, police, prisons, hospitals, and social welfare institutions. Also, under the Defense Act, all members of the army enjoy the right to religious spiritual assistance during their military service. However, there is a strong question of permittance of presence of religious symbols regarding public schools. Some authors find that they are formally excluded by Slovenian legislation, namely Article 72 of the Organization and Financing of Education Act, prescribes that in public kindergartens and schools, or in kindergartens and schools with a concession, confessional activity is not allowed. Confessional activity encompasses the following: religious or confessional instruction of religion with the aim of educating for that religion, lessons on content, textbooks, teacher education, and the suitability of an individual teacher for teaching decided by the religious community, and organized religious rites. In this way, presence of religion is completely expelled from a public space, schools. Because of this, some authors wrote that with this understanding of the freedom of religion and the freedom of action of religious communities of the Constitutional Court, it placed the Republic of Slovenia on the extreme edge in the comparative framework of European countries that the doctrine describes as countries with unfriendly or intolerant models of separation. However, the Constitutional Court, when deciding on the constitutionality of the Religious Freedom Act, said that in the conflict between positive and negative freedom of religion, when positive freedom of religion interferes with negative freedom of religion, negative freedom has no a priori advantage over positive freedom. This means that the right of unbelievers not to be confronted with religious belief, and consequently also with religious symbols, does not always and automatically has precedence over positive religious freedom, which represents freedom to believers to profess their faith and to testify it publicly. It is true that Slovenian model of state-church relations leans toward the French model of laicite, and that the state neutrality is extremely highlighted. That is why Slovenia is among the few European states that do not allow for religious education in public schools. From the wording of the Education Act, it will follow that any professions of religion in public school is prohibited, although the display of religious symbols is not explicitly prohibited. However, it is, as it seems, the consensus between Slovene scholars that displaying religious symbols would breach the duty of the states to be neutral towards religion. From this, a similar conclusion can be reached regarding the display of religious symbols in all public institutions in Slovenia. From this point of view, the display of religious symbols in Slovenia is prohibited in public institutions. However, there is the obligation of the state to enable religious assistance to those who find themselves in particular circumstances. Therefore, there are two possible interpretations of Article 41 taken into conjunction with Article 7 of the Constitution. According to the first, Slovenia is a lay state in which state neutrality is paramount, and display of religious symbols in public institutions violate said neutrality and is therefore prohibited. According to the second, although Slovenia has a symbol of rather strict separation of state and church, this does not mean that display of religious symbols should be prohibited in all areas. Thank you very much for your attention.
Thank you very much, Professor Stanicic, for the analysis of the Slovenian legal solutions.